The story so far. PC Mark Knights is accused of headbutting a member of the public in the face during a civil dispute. The CPS were unwilling to prosecute, as I predicted, and I initiated a private prosecution of my own. After much to-ing and fro-ing, a summons was issued and a plea hearing scheduled for the officer to answer the charges in criminal court. So on to the update. Well, after repeated requests, I finally got a copy of the summons from Derbyshire magistrates. Only then did I discover that the judge had summoned the defendant for common assault only. He'd refused to issue summons for a charge of improper exercise of police powers under Section 26 of the Criminal Justice and Courts Act. I therefore made an application to the judge, inviting him to reconsider his decision. Yeah, that went well. I stated that his understanding of what constituted an offence under this provision was erroneous. The judge maintained his refusal to amend the summons for what I believe are improper reasons, not to mention the procedural improprieties of the initial hearing. Not long after I published my first video, the CPS intimated to the victim that they'd reviewed their initial assessment of the case and reversed their decision. They now decided that they would indeed prosecute PC Mark Knights. I use the term intimated as their communication was ambiguous and contradictory. I've repeatedly asked the CPS to confirm their intentions, and the CPS have repeatedly dodged a question. They did, however, ask me if I intended to discontinue the prosecution. I think we all know the answer to that. So, in the absence of any clarification from the CPS, the private prosecution continues. Due to the COVID outbreak, the plea hearing has been rescheduled twice and it's now set for early July. However, I still maintain that the officer must answer to a charge under Section 26 alongside the charge of common assault. If you or I were to headbutt a police officer, we would not be prosecuted for the summary offence of common assault, but rather for the much more serious indictable offence of assaulting an emergency worker. The reasoning being that emergency personnel undertake important roles serving the public and should be afforded added protection from mindless assaults. I don't disagree with that, but what's good for the goose is good for the gander. Police officers are expected to be held to a higher standard than us mere mortals, and therefore those that choose to exploit their powers of office and violently assault members of the public should expect to face a greater penalty also. A charge of common assault alone is not sufficient in the circumstances, and the Section 26 charge should be allowed to stand. As there is no process of directly appealing the judge's decision, the only alternative is to apply for judicial review in the High Court. So that's what I've chosen to do. I've recently updated my website with a detailed account of how this prosecution has unfolded from start to present. So if you're interested, please head over there for a read. The link is in the description. Judicial review is a notoriously rigid and complicated process that consists of a number of procedural hurdles, each of which can prevent an application from reaching a full hearing in the High Court. At this stage, I have no idea what the outcome will be, but I believe that this is a necessary step, not just for this current prosecution, but as a means to ensure any future prosecutions that I, or anyone else for that matter, bring are not met with the same unnecessary hindrances as this one.